On October 4, 1957, the USSR launched the first spacecraft, marking the start of the space age. Since then, over 6,000 rocket launches have sent about 10,680 spacecraft into Earth's orbit, with 6,250 still in space, but only 3,300 operational. The accumulation of space debris, which now includes over 28,000 tracked objects and about 129 million smaller pieces, raises the risk of collisions, potentials leading to the Kessler effect, making space unusable. The problem of space debris and its potential harm to Earth prompt international legal efforts, resulting in the UN's Convention on International Liability for Damage Caused by Space Objects, approved in 1971. This agreement outlines the responsibilities and compensation for damages caused by space debris. Article 5 of the Convention states that when two or more states jointly launch a space object, they are jointly and severally liable for any damage caused. If one state pays compensation, it can seek indemnification from the other participants. These participants can agree on how to share financial obligations, but such agreements do not affect the right of a damaged state to seek full compensation from any or all of the liable states. Additionally, a state from whose territory a space object is launched is considered a participant in the joint launch. The Convention aligns with other international space treaties, using consistent terminology and universal principles. It defines key terms, damages as loss of life, injury or property damage with compensation based on international law, launching as both successful and attempted launches, launching state is the state that launches, procures or hosts the launch of a space object, and space object as including all parts and launch vehicles. These frameworks connects the launching state, space object, launch act, and resulting damage, ensuring comprehensive liability coverage in space activities.
The Convention defines who can be harmed by a launching state, third-party states and their citizens, residents, or visitors. It excludes nationals of the launching state and the foreign nationals involved in the launch or return operations. Compensation for these individuals is handled through contracts or domestic laws, not the Convention. Claims under the Convention are met at the interstate level, not by individuals or companies. If a private entity suffers damage, their home state or the state where the damage occurred must pursue the claim. If a private entity launches a space object and causes damage, the state from which it was launched is responsible under the Convention and can seek compensation from the company or its insurer domestically. Claims for compensation for damage under the Convention are made to the launching state through diplomatic channels. If diplomatic relations do not exist, a claim can be made via another state or the UN Secretary General. Claims must be filed within 1 year of the damage or its determination, with extensions allowed if the full extent of the damage is immediately known. Claims do not require prior exhaustion of local remedies. To avoid double compensation, claims cannot be pursued simultaneously under the Convention and other legal avenues. If diplomatic negotiations fail within a dispute, with equal representation from both parties and a jointly appointed chairman, if parties cannot agree on a chairman, the UN Secretary General appoints one. The Commission's decision is final and binding if agreed upon by both parties. Otherwise, it is recommendatory. Costs are usually split equally and decisions are made within a year. Extendable if necessary. A certified copy of the decision is sent to the parties and the UN Secretary General for publication. The Convention regulates the liability of launching states, defined as those that launch, procure, or host the launch of a space object. It doesn't address non-governmental actors directly. However, the Outer Space Treaty, Article 7, effective October 10, 1967, and the Moon Agreement, effective July 11, 1984, state that countries are responsible for all national space activities, including those by private entities, ensuring compliance and requiring authorization and supervision. Both treaties hold states liable for damage caused by their space objects. Therefore, liability in international space law exists only between states, which are accountable for the non-governmental actors.
Now let's dive into the event that relates to the use of this convention, which is the Cosmos 9 5-point incident. This incident is the first incident that used the application of the 1972 Liability Convention. In the event, Cosmos 954 was launched by the Soviet Union on 19 September 1977 to outer space. It works as a military satellite which was referred to as the reconnaissance satellite Cosmos 954. Since the satellite was a part of the ROSAT, which is the Radar Ocean Reconnaissance Satellite Program, it was purposely built to track the movements of ships by sending out radar signals which required power from an onboard nuclear reactor. In this incident, the Cosmos 954 suddenly broke down in December 1977, which the Soviet Union unfortunately could not control. Supposedly, when nuclear-powered satellites' operational life expired, they were projected to boost to a high disposal orbit in space. However, Cosmos 954 was unable to perform that activity, which resulted in it re-entering the Earth's atmosphere and crashed on January 24, 1978 in northern Canada. Since the satellite was designated as a nuclear-powered satellite, the debris that was scattered involved radioactive material from the satellite's nuclear reactor, which dispersed a lot of debris all over the Northwest Territories that radiate serious health and will harm as well as endanger the environment. How does this incident relate to the 1972 Liability Convention? This incident is the first incident that laid down the principle of absolute liability of states under the 1972 Liability Convention. Under this convention, when states launch a space object to outer space, they are liable for any damage caused by the space objects to the aircraft while they are in flight or to the surface of the Earth. Canada, in claiming compensation of $6 million from the Soviet Union, relied on the 1972 Liability Convention under the absolute liability provision. Since the Soviet Union is the sole state that is responsible for the satellites, the country is solely liable for the damage that was caused by the space objects to the surface of the Earth of the northern Canada. Rather than bringing a suit to the international court, both countries decided to settle with diplomatic negotiations. On 23 January 1979, Canada's claims comprised the cost of damage and the expenses incurred for the search and rescue operations of the radioactive debris, which the operation was known as the Morning Light Operation. After years of negotiations, on April 2, 1981, both countries agreed that the Soviet Union was liable to pay compensation of 3 million Canadian dollars to Canada. The reason both states decided on settling disputes through diplomatic negotiation was because the 1972 Liability Convention encouraged the states to settle disputes through diplomatic channels. What are the benefits of knowing about this incident? Cosmos 954 incident taught people that under the 1972 Liability Convention, the state or individual or any organization that creates space objects are liable for any damage done by the said object. Next lesson from the event is the significance of international cooperation by both countries in solving the disputes in space activities. Finally, the last knowledge to learn from this incident is the importance of having the space law. Space law was enacted to preserve the peacefulness in outer space and also to address anything that relates to space. The Cosmos 954 incident is a proof of the effectiveness of having the 1972 Liability Convention. Till now, the Cosmos 954 incident remains as a landmark case in the history of space law as it illustrated the practical application of international treaties in addressing the complexities in the outer space sectors.